Hi everyone, we are delighted and excited to have you here and be a part of your journey to exam success. I am Ngozi Emmanuel and I oversee all administrative aspects of the NCA guides. Before we dive into the review proper, permit me to give a broad overview of who we are and what we do. The NCA Guides is a registered partnership of 5 seasoned and experienced tutors who we also refer to as guides. We employ a guide approach because we believe that every candidate has what it takes to successfully challenge the NCA examinations, and our part is to guide the candidate to success. We understand the difficulty that the NCA examinations present, and we help candidates overcome the obstacles and difficulties in understanding the course materials and examination formats. We do this through intensive classes, revisions, and examination review workshops. We do not believe in a one-size-fits-all approach, and our study sessions are focused on helping candidates understand the course material in a way unique and personal to them. In addition, we also offer private and intensive tutoring sessions for candidates who are in need of a direct one-on-one session. If you are interested in registering for our private tutoring session, please reach out to us via email at inquiries@ncaguides.com. Once again, I would like to say thank you on behalf of the NCA Guides team for joining us today.
Hello, good afternoon, everyone, and welcome to the introductory class for the Foundations of Canadian Law. Can you confirm that you can hear me?
Yes, we can hear you.
Okay, thank you very much.
Yes, I can hear you.
Thank you. So welcome again to the introductory class for the Foundations of Canadian Law. Basically, we would, as the name suggests, is an introductory class. So we'll be we'll be going through the syllabus, just like an overview, to familiarize ourselves with the syllabus, and because that directs us to where we should be paying attention to the relevant subjects and the course materials or the articles or cases that we should familiarize ourselves with. So the starting points is the syllabus. So let's familiarize ourselves. It's very important for us to get familiar with the syllabus, and that even in an exam scenario, that also assists, such that when you are familiar with a particular topic, you can, in answering the question, you can focus on the particular topic. You will have an idea once you are familiar with the syllabus and you have a question. You will have an idea that, okay, is this the answer in this question is in chapter 1 or chapter 7 or chapter 10. So that's part of the advantages of familiarizing ourselves with the syllabus. Just to note as well that we would like the class to be interactive. So I don't want to be the only one talking. I want to hear your view. I want to hear your perspective as well. And so that we can, I believe that is the best way to learn, when we hear from one another, when you introduce your perspective, and we can look at it together. Sometimes there is no right or wrong answers to these things. It's just, and as lawyers, we will know that arguments can go either way, and it depends on the force of your arguments and the conviction that is backing them as well. So in that light, I would like us to, as much as possible, have a participatory session. As we are aware, in earlier this month, the NCA updated the syllabus for the Foundations of Canadian Law. So if you were preparing before October, you should be aware that there is a revised edition for there was a revised edition this month, which which you will be using to prepare for the exams taking place in February. What we do at NCA Guides, as the introduction suggests, is to guide you through the exam process. From our experience, the areas you should pay particular attention to. And I mean, there is nobody that will tell you that this is an area of concentration, but every aspect is important, and the foundations of Canadian law is so broad that the NCA every now and then they can pick questions from different places, and just even from very minute detail that you might not pay attention to. So that's why it's important to understand the different areas of the subject. So what we do at NCA Guide is to guide you through this process and sort of call your attention to areas that you should be familiar with. I've mentioned the syllabus, so of course there is the textbook as well that you should also be able to familiarize yourself with. For me, I think the textbook is very helpful, and it's quite, the language is very simple and relatable as well. And you should try as much as possible to consult the textbook. In case you prefer not to use the textbooks, there are also notes. We have the manual notes that NC that is available on NCA Guides website, so you can get that from the website as well. That also is quite helpful in the sense that it simplifies some of the topics and use fewer words or summarizes them if you do not have the patience to go through the details of the course materials. One other point note, sorry, can we mute our mic if we are not talking so that we don't distract others? Right. So one other point to note from the revision of the NCA guide syllabus in November, that chapter 2 and chapter 10 in particular, you should pay attention to that because a lot of changes occurred between this syllabus and the old syllabus. So in chapter 2, they replaced a whole number, I think about 6 articles in chapter 2. So they removed the old ones and replaced the articles with new ones in chapter 2. In chapter 1, there's additional reading in chapter 1. So we'll go through this chapter by chapter just to get a high-level summary of the course materials. I also mentioned that chapter 10, the November version of the syllabus introduced a wholesome changes to chapter 10 as well, replacing the old articles with new articles in view of the landmark decision in Vavilov. So there are a number of the decision itself, the Vavilov case itself, and also the articles that have been written about that decision. So a number of them are replicated in chapter 10, and the fact that the Dunsmuir regime is no more, so that sort of meant that there will be wholesome changes, or there were wholesome changes to the articles in chapter 10. So let me stop here, and let me hear from anyone, any volunteer, where the level of their familiarity with the syllabus, if they've gone through the syllabus, what is their experience, how are they looking at it, and what is their first impression about the syllabus. Any volunteer, please.
So for me, this is like my name is Naomi. This is my first time of attending any session on foundations, and I was studying initially like 6 months ago, but I didn't get past 2 chapters, and now I hear they've changed the whole syllabus, so it's like zero for me. I have absolutely no knowledge of foundation.
Okay, thank you, Naomi. I can tell you that it is not zero for you, so don't say that it's not zero for you. Your familiarity with the old syllabus will still help, right? So some of the chapters are basically still the same, right? The topics are the same. What has changed significantly are the materials, and it is not all the chapters that the materials have been replaced altogether. So I mentioned that chapter 1, an article was introduced. Chapter 2, significant changes, a whole lot of, I think about 5 or 6 articles were introduced and replaced with some the old articles that were removed, right? So pay attention particularly to chapter 2 and 10. Those are where the changes are quite significant. But in other chapters, chapter 3, 4, 5, they are still very much the same, and your past experience or familiarity with the syllabus is not zero. I can assure you that. Any other taker? Let me hear from you, please. Anything, I mean.
What's the question? Sorry.
Okay, my question is to share your experience with us on how familiar you are with the syllabus, if you've gone through it previously, and what are your impressions about your.
Okay. I have gone through the syllabus. I did go through it, but I don't think foundation is straightforward. I find it highly jurisprudential. Like I think it's quite technical. I think so. It scares me. It scares me, so to say. It's too jurisprudential for me.
Okay. Thank you, Aisha. You are absolutely right that foundation is jurisprudential, and you are absolutely right as well that it is technical. So, but when you calm down and sort of look at it very closely, I can assure you that it's not insurmountable. And what we'll try to do in the class is to break down this jurisprudential barrier and crack that nut as well as much as we can. It's a lot of work. I will be honest with you, because there are more than 30 articles that you need to read, and each article on the average is about 30 to 40 pages. Some of them are short, some of them are long. So it just means that you need to spend some time to get familiar with the course materials. But the materials are some of them are complex, very jurisprudential, particularly chapter 1 when you talk about legal positivism and all those theories of law, which we'll go through on a high level basis shortly. But I believe when you get familiar with it, read it once, twice, thrice, you will be fine. You'll be able to relate with it as time goes by. And as much as possible, we will be here to support you through that journey. Can we take one more person, then we can dive straight into the course material?
Hi, my name is Semirat. This is my first time doing anything on foundations because I've heard a lot of scary things about foundations. So I'm just trying to get familiar with it and decide when I'm going to write the exam.
Okay. Thank you very much, Samira. What I can tell you is that you shouldn't be scared. Don't listen to fear mongering and all that. Your work is quite cut out for you. So for foundations, it is what you give is what you get, if I can put it that way. It requires a lot of work, I can assure you that, a lot of dedication and maybe more time than other courses. It requires that, but it is also quite interesting and I don't want to say straightforward, but it's quite interesting once you give it the hours that is required. You just need is a lot of work, no question about that. And we'll just see how we can support one another through the process. So thank you very much for the contributors. I appreciate your perspective of it, and that will sort of assist us in going through this course. First, the NCA exam. If this is your first NCA exams, the objective of the Foundations of Canadian Law is to provide an overview of Canadian legal system and the role of law in the society. So in foundation course, you will see reference to other courses as well. So you see reference to administrative law, you see reference to criminal law, and you see reference to constitutional law in particular. So all these it's like the name suggests, is a foundation of Canadian law. So it is the basis, or it explains or addresses or discusses the basis upon which the entire Canadian law is built. So don't be surprised if you've written admin law previously, you don't be surprised or alarmed to see cases on or references to admin law in foundation. If you've written criminal law previously as well, or constitutional law, don't be surprised that you will see a lot of constitutional inferences under this foundations course. So what it does is to provide introduction to an overview of the Canada's legal system. The second objective of the course is to review various legal theories as they apply to Canadian law. So we know the theories of law, and we'll deal with that in chapter 1. So the naturalist view, the positivist view. So what is the core of the naturalist view of law? What is the core of the positivist school of law? What is the core of the feminist perspective of law? What is the core of the economist theory of law? So we will look at all these aspects in under this course, and that is the core of what chapter 1 discusses. Then the third objective is to introduce the overarching legal framework within which the particular areas of law studied in other courses operate. So I mentioned this under item 1, which is to introduce you to the general foundations of Canadian law. Another objective of the course is to acquaint applicants with the various sources of Canadian law. So what are the sources of law in Canada? We have the common law is a source of law. We have the civil code is a source of law, and the Act of Parliament as well, and the judicial pronouncements or decisions or case law, if you like, as sources of law. So we'll get familiar with all these sources of law. Another objective of the course is to compare the different branches of Canadian government and to analyze the relationships between and among them. So what are the different branches of law, of government, the executive, the legislature, and the judiciary, and how do they relate into say? That is part of the discussions we'll be having in this class as well. also is to provide applicants with understanding of the Canadian treaty-making process and the implementation of international law into domestic law. So what is the status of international law within the Canadian domestic law? If there is a conflict between the international law and Canadian domestic law, how is that resolved? How are laws interpreted, or how are interpreted within the context of international obligation of the Canadian state? So foundations of law will also be discussing that in this class. We'll also be discussing the special relationship of Aboriginal people with Canada or with the Canadian state, and to also enable us to critically assess the impact of the Canadian legal system upon Aboriginal and minority communities. So, I mean, if you've gone through the materials once, in chapter 2 is all about Aboriginal rights and title. Who are these Aboriginal people? What is their level within the Canadian legal system? What is the status of Aboriginal law within the Canadian system? Do they have a special status? Some of their rights have been entrenched in the Constitution. What does it mean for their right to be entrenched? What is the implication of the entrenchment of the rights of the Aboriginal people? The Aboriginal people, any dimension that was introduced by the new syllabus is the extraterritorial application of Aboriginal rights and title. So can somebody who claims to be Aboriginal but is not a Canadian, maybe is an American, can they come to Canada and exercise Aboriginal rights in any of the provinces in Canada? How does the Canadian legal system view that kind of exercise of rights of Aboriginal rights by non-Canadians? Very interesting perspective as well. We'll be looking at that in this introductory class as well. One other objective of the foundations class is to provide applicants with an understanding of the nature and function of judicial review and the basic approaches to statutory interpretation. So how are statutes interpreted, Canadian statute? What is the principles of interpretation of Canadian law, right? And what is judicial review? What actions are subject to judicial review? Actions or decisions of private bodies, are they subject to judicial review by the Canadian courts? So those are some of the nuances that we should pay attention to under this course, and the materials will be discussing that as well. So very briefly, I mean, we've run through the objectives of the course. With this objective in mind, I think we should have all these objectives at the back of our mind. That is how we should approach the course, and we'll see it play out in different areas of the course. In relation to the exams, the exams are busy because, I mean, the most important thing for us is to pass the exams. Yes, we want to have knowledge about the workings of Canadian law as intending practitioners in Canada, but our immediate objective is to understand the exam framework. So the evaluation, as you're aware, it is an open book, so you can go to the exam hall with all your materials. And these days it is administered online because of the COVID situation. As far as we know, that will be the situation as far as we know until communicated otherwise by the NCA. So it's an open book exam. You have you take all your course materials. You have an exam proctor who is going to monitor you through your device, maybe a mobile or a tab or a similar device. So the questions are different types. So some of the questions consist of short answer questions. So it is more like a yes or no answer, or like an objective OBJ question to say who are the Aboriginal people, for example. I mean, they will not ask simple questions like that, but they can I'm just giving it as an example that if they ask who are the Aboriginal people, so the Métis, the Inuit, and all that, so that's like a short answer, direct to the point, no story, and all those kind of stuff. That's one kind of a question. Another type of a question is essay questions, which sort of try to test your familiarity with the materials, right? And which is why it's quite important. And you can't be so sure of what materials that they will ask the question from. So it's important to, as much as possible, familiarize yourself with all the materials. Sometimes your answer can be in a material, can be in a particular paragraph in the materials. I remember when I was when I wrote my exams and they asked a question, right? In my head, I knew where the answer was, right? And I knew where the I knew the materials that had the answers, but unfortunately for me, I didn't print that material. I didn't take it to the hall, right? And yeah, I just used my intuition to answer that question. So I don't know how well I was scored, but the important thing was that I wasn't asked to come and write the exams again. So it underscores the importance of having your materials ready and being familiar with your materials. So sometimes, like I said, it is not every paragraph of the material that is relevant. The answer, it is just in one paragraph, and it is that kind of, when you understand the materials or familiar with it, you'll be able to pinpoint or go directly to where your answers are. So essay question is more like a theoretical question that they will ask to see if you understand some of the concepts that they are discussing. So do you understand the concept of judicial review, or separation of power, or parliamentary sovereignty, and that kind of stuff? They can ask questions around that. Another type of question that they ask is problem question. So this, as we are lawyers, right? You know, you deal with live cases when you're in practice. You will not be dealing with theoretical cases, you know, you'll be dealing with live cases. So they will paint a scenario, and NCA likes that kind of exams a lot. I mean, most of their questions are problem questions, really. They paint a problematic scenario, and they ask you to dissect some of the legal issues there. So what will certainly help you in answering this kind of question is your understanding and familiarity with the course material. If you don't understand the course material, if you're not familiar with it, I assure you it is quite easy to go off points, you know. So, and sometimes the questions are so lengthy that I mean, there was a year in I think admin law, the question was just one question, and it was like 2 or 3 pages, I can't remember, but inside that question embedded different aspects of the law. So your job under that kind of a problem question is to dissect the legal issues. I mean, they can paint a scenario of Aboriginal rights or Aboriginal title, and what they want you to do is to look at the cases like Vanderpeet or Silcotin, and show us how do you prove Aboriginal rights and title, and what are the indices or indicta that the courts will look at in order to show that you've proven Aboriginal rights or title. So, like I said, it is when you are familiar with this with these cases and materials that you'll be able to pinpoint some of these intricate questions. So in summary, your question can be 3 types. It's a short answer question, which is like an objective, essay question, which is to test your familiarity with the materials, and problem question, which is to test your understanding and your ability to apply some of the things that you've learned into real life situations or real life scenarios, right? Any question, contribution so far? I'm with you. Any question or contribution so far?
No, no questions so far.
Okay, thank you, Aisha. Dara, do you have any question for me or contribution?
No questions or contributions so far.
Okay, thank you. Are you following though?
Yes, I am.
Good. I mean, feel free to jump in. I just don't want to be talking to myself. So Fumilola is raising her hand. Please go ahead.
Wow, so will it be okay in deciding to start the NCA exams to put foundations of Canadian laws at the back burner? This is the third class I'm attending today, and the foundation seems too much. So from your own judgment, would you advise that foundation of Canadian laws should be dealt with like later on? I wouldn't want to start the exams with foundation of Canadian laws with all this that you said.
Oh, so it's like I've scared you.
Not really, but it looks wider than professional and admin that have sat in the class today. It looks like there's so much to deal with as far as, well, it's expected. It's just like, I'm a Nigerian, so if you're talking about Nigerian administrative or constitutional law, I'm sure it will be so wide. So I'm thinking if I have to compare, foundation of Canadian law seems wide.
Okay.
No, I just want your own professional opinion because you've been through it all. Talking to someone that is just starting, would you say it's best to just put it at the back burner and just know that, okay, you put your energy on that after you've done every other exams?
Yes. Yes, I think you should. It's my last paper.
Okay, Aisha is your last paper. I see. Okay. I have a different view. My first exam, I was advised as well that I should take foundations and probably admin law or constitutional law together. That was the advice that I received. And it was a consistent advice, not just one person or two people gave me that advice. And having gone through the exams, my judgment is that it is advantageous to start with foundations.
Ah.
Yes, Aisha. Yes, Aisha. So why I am suggesting that is because once you're familiar with foundations, I assure you, you're going to find other courses easier. That, at least that was my experience, because in foundations, you have constitutional law. In foundations, you have criminal law. In foundations, you have, what is this other course? Admin law, exactly. And Aisha, I believe you can testify to that if you've gone through the materials. So if in one course I can get exposure so 3 other courses at least, then I think that course I should take that course first to make other what's it called, other courses sort of quite easier for me. At least that was my own experience. So I would recommend, again, it depends on individuals. So some think they should start from the less intensive ones and move gradually to the more intensive one. But some will take a different view, that the hard work is when you are trying to crack enough. Once you crack it, then when you go in, everything will be easy. So it depends on your perspective, really. I mean, if you are trying to get water out of mountain, where is the work? Where is the work? At the first crack, when you are trying to crack it, right? Once you crack it, you see that your journey would be easy. So what I did was I took foundations, just foundations alone, right? And I wrote the other 4 courses together, right? So the only course I wrote alone was foundation, just because of its intensity, and I wanted to get familiar with the Canadian legal system, like the objective of the course suggested. Once I did that, I think I found it more relatable to take the other 4 courses together, because I mean and they were not strange to me when I was reading them, because I mean, constitutional law, I already went through section 35 in foundation, section 35 and section 94 in foundations. Admin law, I already went through the judicial review process. Then it was the Dunsmuir regime that was operational, so which is also replicated in admin law. So reading that in admin law, I didn't find it strange at all. In criminal law as well, a whole lot of the cases that are used in constitutional law are also replicated in criminal law. So it was quite of sort of straightforward for me. But again, it depends on individual. So if you ask me, I would say take foundation, right, and then you see that other courses will be you'll be familiar with other courses as well. Aisha, you want to say something?
No. No, I don't. I mean, from your reasoning, it does make sense. Like, well, to me, Sha, I still personally, I wouldn't still do that if I have to make the decision again, right? I think it's just too technical because it will scare you. It will just scare you off. So I still believe it's too technical to start with, Sha. So I started with admin and constitution, right?
Okay.
So, and that worked for me. So if I have to make this decision all over again, I still won't start with foundations.
Don't worry, you won't have to make the decision all over again.
Yes,
You've written it is gone.
I won't at all. So yeah, that's it. Foundations is too technical.
Okay, that's fine. So I think it's whatever works for you, really. I mean, it's the strategy worked for me, and so just decide what works for you. Sometimes people people are scared of volume, and if you are someone that is scared of volume, maybe foundation might scare you. But if you are not scared of volume and
You like challenges.
you prefer to do the hard work first, then I think the approach I suggested might work for you. So again, you decide whatever works for you. In any event, our NCA guides will be here to support you. Any other question? Contribution? Okay, right. I think we can go through the syllabus now. And like I said, it's just to provide overview. So we are not going to go into, it's just high level discussion. We are not going to go through any granular details. The proper class will start December 5 and will end January 9. And because exams are scheduled for February 8th, all through that week, February 8th to February 11th. So what NCA has done is to introduce flexibility in taking the exam. So you can choose different dates within the week and take your exams. The exams, don't think that if you write on Monday, you will get the same question as the person that writes on Tuesday. You can't be certain of the question that you get. It's of different types, type A, type B, type C. I don't know up till what type. So they use different types of question. And also, if you are not familiar with the course, the fact that you are even told of the about the question, that they even say this is exactly the question, is not a guarantee. It doesn't guarantee anything, you know. So the key thing for me, I think, is to familiarize yourself with the materials. You can, yeah, I mean, past questions are helpful and they sort of guide you on what to expect and how to answer some of their questions, right? So they are quite very helpful. But even when if they give you the questions ahead, it doesn't guarantee anything, because your lawyer skill, your writing skill, and all those kind of things, those are the things that are being tested, and it's not going to appear once. It's what you have prepared for over time. So the exams are in February, like I said, and our preparatory class after this introductory class will start December 5, where we'll go, we'll be more granular and try to analyze some of the articles and discuss some of the issues and our typical problem questions or problem scenario. You can go to our website, www.ncaguides.com. You can email us at inquiries@ncaguides.com, and you can, sorry, Naomi, you raise your hand. Please go ahead.
Yes, sorry, I'm just asking about the schedule for the preparation of for the exams. So, like you said, there is a class in February, but I was thinking of writing the exam in February before, but now that I'm hearing all these things, I'm thinking I'll just push it back. So there is another one in May, and I'm just wondering, would there be another class in April, or this is it for the year?
No, this is not it for the year. So first of all, please write your exams in February. Don't be scared. In fact, I take back everything that I've said before.
Yes, so me too. I take
very
mine back
easy.
too. Right?
Foundation is the easiest course.
No, I'm just thinking.
He's right, people. Doable.
So,
I'm just thinking, sorry, yeah. I'm just like, if foundation, it's ironic because foundation is supposed to be like the bedrock of everything, like from what you're saying. So you might get knowledge for others from it. But from what I've heard, even before this class, I think it's better for me if I use all my knowledge of admin, constitution, criminal to understand the foundation. So instead of using foundation to understand others, let me pack all the knowledge of the others to understand foundation. So I'm thinking that's what I'm going to do.
Okay, in terms of our classes, we will run foundation classes in April before the exam. It will probably start in March, so that it runs through beginning or mid-April, so that you are able to prepare for the exam. We also run like exam review classes. So in the exam review classes, what we do is to deal with problem questions. So we'll take a problem scenario and then try to analyze it, all the legal issues and what have you. I believe, I mean, if we are, today is 21st of November. I believe if you want to write in February, you can write, right? Because you have the whole of, you have, about more than a week, about 10 days in this month, and you have the whole of December. And
oh, I'm writing constitution in January, so I was thinking of combining constitution then foundation. So now I'm thinking I'll just give it all to constitution, then give some time to foundation.
Okay, whatever is convenient for you, really. I think you can write the two together because the constitutional law and foundations, there is interrelation between them. So the amending provision that you come across in constitutional law is inside foundation as well. Section 35, Aboriginal right, title, and all that is in foundation as well. Section 94 about the entrenchment of the control of the federal government over Aboriginal matters is also in constitutional law, is inside foundation as well. I think you can combine it, but I mean, it's whatever is convenient for you. But as for whether there will be NCA guide schedule in April for foundations and for all other courses, yes, there will be. Right, so we run it through the year. So previously, all the exams were available in every quarter, right? But they've changed it now such that some exams are not available in a particular month. They are still available every quarter, but not month by month. So it's now monthly. That's how the exams have been scheduled. So for the foundations class, yes, we will run it for the May exams, and we'll also run it for, I think after May, there is another one in, is it August also? I'm not sure. So we'll also run it like that. We'll run it through the year in accordance with the exam schedule. Yeah. Right. So please don't be scared about foundations. It's in fact is the most delightful course, right? And it's the most delightful course, I would say. You can drop me an email at masood@ncaguides.com. Masood, MASUD, at ncaguides.com. So, and I'll be happy to assist you. Right. So, I'm not sure I introduced myself, did I? Did I? Naomi, did I? Okay, sorry about that. I was so engrossed with starting the call. So my name is Masood, and I'm the guide for foundations. Right. So let's go through overview of the course. Right. So chapter 1 talks about. Who can tell us what chapter 1 is about? Anyone?
Talks about the basic theories of law.
Basic theories of law. Thank you. Basic theories of law. Does anyone want to talk about what their perception of theories of law are? Anyone? Oyindamola, do you want to try? You let it pass. Let me hear your voice.
Okay, good evening. I'm going to let it pass. I'm just really fresh. And I'm actually yet to get my assessments. I'm still on it. So I'm just familiarizing myself with everything pending.
That's fine, Oyinda. Yeah, Aisha, you want to say something?
Okay, the basic theories of law, there are 4 different theories. So there's positivism and natural law. From what I understand about it, I think positivism, that one talks about like law as a command issued by like an uncommanded commander, like they are man-made man-made laws backed by the authority, legislative backing, that's legal positivism, so to say. And then for natural law, that one is just basically saying that laws, that one is like, it goes with your morals, like it looks at the moral standard, and he holds it across board. So if I believe that it is wrong, every other person should believe it is wrong as well. That's what I understand from natural law. Then feminist perspective on laws. From what I read, I think the earlier on, women were not allowed to vote. They couldn't hold seats in the Senate. And then I think 5 people came together to sue, I don't know, to give them a voice to hear. That's where the Edward case came in. And then women were allowed to vote or something of the likes. That's what I understand from that. They should try to be, it should just be gender neutral and not to be biased or something against anybody. And then critical legal studies. What does that one say? I don't know if I understand that one. Okay, I think that one is just saying like the rules were neutral and objective, and then the rules could be determined with certainty. I think that's what that one is talking about. There's a case under it, R against SRD, but I didn't read it yet. And then law and economics, I think that one applies to economic efficiency, like ideas where the welfare of the parties can no longer be maximized except at the expense of the other parties. So that one is just looking at the theory on public law, like on how to maximize the support for the public, basically. That's what I understand from that for.
Thank you very much, Aisha. I mean, you are spot on. That's the summary of chapter 1. I think we can move to chapter 2 now, right? Right. So yes, you're spot on. Thank you for that very fine summary. So basically, the chapter 1 talks about the theories of law, and as Aisha mentioned, we have the legal positivism, we have the naturalist school of law, we have the feminism school of law, and the economic theory of law as well. First, we talk about legal pluralism. So what does legal pluralism mean? So it's about different legal system or legal concepts operating in the same legal system, right? So, and as we'll see, that legal positivism and naturalist school of law, they are not against one another. They are not words and opposites, so to say. Both theories of law, they assist in us in understanding the law, the operations of the law. Legal positivism is championed by John Austin. What he says, as Aisha mentioned, is that law is the command of the sovereign, right? That is given by an uncommanded commander. So it is just to say, you do this, you do that, and everybody obeys. But as we will see, law is not, the nature of law is not only about command, right? It's not only about command. For example, a law that says, that prescribes how marriage should be done is not commanding everybody to go and get married. It's just prescriptive, just defining what will constitute marriage and what the law will regard as marriage, right? It's not a command of the sovereign, of any sovereign. So naturally, school of law, so that's about positivism, saying law is, another aspect of positivism is that law is what has been dictated, what has been said. It is not your morality that is the law. So I can say, based on my own cultural or whatever beliefs that I have, certain things are not allowed. What the positivists are saying is that that's my opinion or perspective or my impression about whether an act is lawful or not lawful does not make them the law. It is when it is codified and written in statute book and somebody has said, don't do this, don't do that. That is what makes it law, right? That is what the positivists try to say. Why the naturalist a school of thought say that law is not what determines what is right and wrong in the society. You know, what's the relationship between law and morality before you criminalize certain acts. So if you say bestiality, for example, is unlawful, or taking certain drugs or what have you is unlawful, or having sexual relations with minor is unlawful, what determines how you came about that decision? The naturalist school say it is morality. Is because we all have a conception about what is moral in the society and what is not moral, and that a law really, that if it is not rooted in the morality of the people, that law is never going to be followed, is never going to be obeyed. So it is not just for the sovereign to come and say you should do this or you should do that. You should look at the culture of that society, the moral view of that society. What is moral in certain countries or jurisdictions is morally neutral in other jurisdictions, right? So before a law can be enacted, morality also has a role to play in that in the enactment of that law. That is basically what the argument between the positivist and the naturalist what is talking about when we grind it down. So here we'll be talking about natural law as propounded by Aristotle and Thomas Aquinas. And you see that like Thomas Aquinas, for example, is a Catholic, is a prominent Catholic figure, right? And his own perspective of law came from his Catholic view of law to say, what has God asked us to do, right? And it is those things that are informed or influenced by his own morality that he views as law. So both naturalists and positivists are concerned with the concept of law and justice, even if they differ on how they relate with one another. So the course material gave example of relationship between law and morality in the case of Drummond Rand and law, and between law and positivism in the renewable and Wolf case. You know, so in these cases, there was a time that it was prohibited to sell land to Jews or certain group of people. And what the court said is that you can't have a law that discriminates against people because of their background or racial inclination. That law is against morality and it's against the fabric of the Canadian society, and that law was declared to be illegal, and it was not enforced. So what did the judge do in that case? It looked at the law and morality, the importance, the relationship between law and morality, and how that influenced the law, right? So that was what was at the core of the mind of the court in that case. In a similar case, I mean, the court upheld that the rules of the society that says that you shouldn't certain sects or group of people are not allowed within a particular premises was not, there was nothing wrong with that, because that is what the law says. So that in that scenario, the court was taking the positivist school of law to say law is not determined by morality, it is what is written black and white that will be would determine the law, right? So another perspective of law is the feminist perspective, and what this does is to look at the history of law over time and how it has discriminated against women in particular, right? So in terms of the right to control their body, in terms of their rights to vote, in terms of their right to occupy certain positions in the society. And the case in point is the Edward and Canada, which is called the person's case. And what the law say then, because the language on the Constitution about representative or representation in the Senate was masculine, right? Then, so because the language was masculine, women were not allowed to represent to be appointed into the Senate, right? So in that case of Edward and Canada, what did the court do? It used the doctrine of the living tree to say the law is not a fossilized object in the Museum of Antiquities. The law can live, right? It can develop, it can grow. So because the law is influenced by the thinking of a particular society at a particular point in time. So the thinking in medieval times is not the same thinking in modern times. So in medieval times, there were laws that were enacted that disinherited women, that sometimes we might have to change those laws, right? But some other times we can use the principle of interpretation under the feminist theory of law to say that let's use this law to protect women. Let's use this law to promote equality between the male and the female. So the language of the Constitution about representation in the Senate did not change, but what it is that the law was reinterpreted using the doctrine of a living tree to say that this law cannot be cast in stone, and we can use the feminist perspective of law to allow women or female to have Senate representation, right? So similarly, the case of R and Magentella, and how that relates to the Section 7 of the 1982 Canada Constitution about life, liberty, and securities of person, which talks about the right of women to control their own body, right? So that section was interpreted such that it gives that anything that prevents women from controlling their own body in such a manner that it threatens their life, it threatens their liberty, and threatens their security of persons is unconstitutional. So that's the feminist perspective of law was adopted to give women the right to control their own body. The critical legal studies is about law and realism. And what it says, the summary is how law in practice reflects our practical and social experiences and prejudices, that there is no neutrality in law. So that perspective is that you can't say any law is neutral, you know. So if you come to certain, if you go to certain countries with certain cultural or religious inclinations, it is those things that will inform their law, their perspective, or the perspective of their law. So if you go to other countries with different perspective and different inclinations, you will also see that some things are not necessarily legal or illegal. So the critical legal theory says that our experience shape our perspective of law. So if you go to the US, for example, the Republican and the Democrats, right? The Democrats, they embrace liberal values because of their own perspective of the law, while the Republican, they are more conservative, and they have different views towards things like abortion and things like that. So when they come to government, what they try to do is to push this agenda, whether it's a liberal agenda or a conservative agenda. So critical legal theory, studies or theories basically tells us that law is not neutral, right? Everything that is law depends on the perspective and the social background of all the makers of those laws, and that attack on legal traditional formalism does not necessarily lead to justice, you know. So we have to look at things from different perspectives. Another theory of law is the law and economics, and what this does is to apply basic economic model to legal rules and policy to assess whether they will result in outcomes that are efficient. You know, if you understand economics, what the theory of efficiency, to say that law should pursue objective that achieves the greatest good to the greatest number of people, right? So if you have, for example, if government want to spend and want to pass a law on spending, so they should analyze the impact of that law. If it is going to affect, let's say, 10 million people, if it is passed, and they should pursue that kind of law. But if a law will only affect, let's say, 1,000 people as opposed to 10 million people, they should do a cost-benefit analysis and use the theory of efficiency to pass that law. So law and economics, the economics has a role to play in the enactment of law, and law that will pursue the greatest happiness for the greatest number of people is what should be passed. So economic theories have been used to explain contract law, torts, family law, property law, legislation, and what have you. So essentially, it is just saying that law should seek to maximize the greatest benefit for the greatest number of people. It also says that politicians that are passing the law, they are acting not in social interests, but in economic interests. And what is the economic interest? To maximize political support. You know, so to maximize political support. So politicians will always push for law that will make them more popular, as opposed to laws that will make them unpopular. So those are some of the perspective of law. So we mentioned 4 perspectives: the positivist, the naturalist, the feminist, and the economic theories of law. And what all these perspective of law, what they do is to help us to understand the law. So you can't say law is only positivist, or law is only naturalist, or law is only feminist, or law is only economic. No, all of them, they shape our understanding of the law. Am I making sense?
Yes.
Yes, yeah.
Oh, I'm
Yeah.
not making sense. I'm speaking too much grammar.
No, it's making sense.
Right. Thank you. So under this topic, under chapter 1, you have 3 articles. So one is on legal positivism, which which we've discussed in some detail. Then the other is article by Rimbadi, Arabs, Muslims, Human Rights, Access to Justice, and Institutional Trustworthiness. So very quickly, what that article says is that law in the books is different from law in practice. Procedural access to justice deals with the barrier accessing the legal system. Substantive access to justice deals with the relationship between law and justice. So what is procedural access to justice? What is substantive access to justice. It also talks about sociological access to justice, and this speaks of what are the conditions that encourages people to access the legal system, you know, and if the law is operate in such a way that people do not trust the system. You know, in some countries, people just feel frustrated and say, why should I go to court? I mean, if I go to court, I will not get anything out of it. So what is the point of going to that court? So that's what sociological aspect access to justice deals with. That what are the conditions that encourages people that encourage people and build their confidence to approach the legal system. So it also talks about institutional trustworthiness. So and how people trust the system, and particularly minorities. So it chronicled the experience of people with certain social markers in Canada, the Arabs, the Muslims, and their relationship with human rights. It identified about 9 cases where people spent different times in courts, right? And they did not get justice from the system. So it says that, look, it is not just enough for you to say you have enacted human rights law. You need to look at the experience of these people, the people you want to protect based on this human rights law. How comfortable are they with the system? How easy is it for them to access justice? So if the cost of access to justice is so exponential that these minority people, they can't even they can't pay lawyers in order to get justice from the court. So what is the point of having that human rights law? Have you done anything to make access to justice easy for them, right? So that article chronicled the experience of about 9 different individuals who had interaction with the legal system, and how their experience shaped their perspective of law. Because some of them, the courts or the judges, they didn't even understand what their issues were, right? Things that were discriminatory, because the judges are from a different background, they didn't even understand how you can cause those kind of things discriminatory, right? And these people, they also spent significant lengthy time in the courts, right? Some spent about 9 years, some spent 7 years, some spent more, you know, and they were worn out psychologically. So this article examines that challenge of access to justice, to say, look, if people are in if you've created law, if you enacted law for the benefit of certain group of people, and they are not getting benefits of that law because of one barrier or the other, then what is the point about enacting that those laws? So that's basically what that law, what that article speak to. Then the other article is arrested, injured by Robin Maynard, from the streets to the prison in policing Black lives, state violence in Canada from slavery to the present. So in summary, this article talked about the discrimination against the Black people within the Canadian legal system. I mean, we are all familiar with the Black Lives Matter protest in the U.S., which was instigated by the death of George Floyd, or by the killing of George Floyd, among other people, other victims. I mean, there was the Abri guy that was also killed, not by police but by private individuals. So that's injustice and discrimination that the Black people face in the US is also replicated in Canada, right? And what the article says is that, look, why do you have more Black people in prison or committing offenses? It is, and it says it's not because Black people are worse than other people or other racial group. You know, Black people are not intrinsically more criminal than white people, but it is just a self-fulfilling prophecy, because you are looking for crime within the Black community, you are going to find crime, right? So if it's that you treated everybody equally, and you do not have a preconception that Black people are innately more violent or more criminal than other people, then you are not going to find a lot of Black people committing crime. But because you already, due to slavery, I mean, there is this slavery antecedent, how the Black people were transported across Europe and North America in chains and what have you. So already you have that prejudice against them, and you now believe that, I mean, also because of their social class, when you transported them from their countries to your country as slaves, they were at the lowest rung of the ladder in the society. So they were the poorest people, they were the least educated people, they were the least exposed people. You don't build infrastructure in their community, you don't pay attention to them. What do you expect? Right? So it's a self-fulfilling prophecy. It is not as if Black people are more violent or more criminal than other people. When the article talk about the concept of carding in the Canadian society, where I think it gave example of Toronto in particular, where police, whenever they interact with a Black person, they sort of keep a database of those Black people, right? And when there is a crime, right, it is the focus on that data, right, to sort of suggest that it is those people that are criminal. So that's why you also find out the police, they stop when they see a white driver and a Black driver. They are more likely to stop that Black driver than stop a white driver. And what are they looking for? They want to know whether you have committed one offense or the other. So he argued, the author argued, that if you stop white people at the same range or at the same level at which you stop what's it called, Black people, you are going to find the same crime, right? So I mean, that's the summary of that article, to say that the legal system in Canada sort of discriminates against Black people, and it is not because the Black people are more criminal than the white people, but attention, or there is more focus on looking for crimes within the Black community than the white community. You will see that when a Black person and a white person commit the same offense, the white guy is more likely to go unpunished than the Black guy. So when you punish the Black guy, of course you are going to find a lot of them in prison. So that's what chapter 1 is all about. I don't know if there's any question, comment. You'll see that it's very simple and straightforward. Naomi.
I'm actually enjoying the class. I'm beginning to it's like, from what you're saying, it sounded like, oh, it's just stories and like, but I don't know. I've not
It's very
attempted any
simple and
question.
straightforward. I assure you. It's just that, I mean, I won't deceive you. You will spend more time in reading, right? But it is quite simple and straightforward. There's nothing complex about it. And chapter 1 is easily the most complex. And you see how we have broken it down to say, because that's where you have the legal theories and some abstract things by Hans Kelsen and all those philosophers and thinkers, and you can see how it went. It's quite straightforward to me, honestly. Samira, any comments?
No comments from me.
Okay,
what I'm enjoying the class, like you are giving us perspective about foundations, because usually when you hear foundations, you're just like, oh my, foundations, but now you are really simplifying it. So thank you so much for that.
You're welcome. So I assure you, honestly, it's quite straightforward. It just requires more time, no question about that. But there is nothing so abstract about it that is insurmountable.
Thanks.
Okay. So our time is fast spent. I will just run quickly to chapter 2, which talks about indigenous people and the law. So who are the indigenous people of Canada? I mean, they are the people that were here, that occupy the native of the land, that came before the European, and you and I that are immigrants or intending immigrants to Canada. So the indigenous people, they are the native of Canada, right? So what is their rights? Their rights and the title. So what right do they have, and what is the title to land that they have? So we also discuss indigenous self-government aspirations and the modern treaty making process. So very quickly, right? We'll focus our attention on the section 35 and 91 sub 24 of the Constitutional Acts. And what does section 35 of the 1982 Constitutional Act, what does it say? It says that the existing Aboriginal and treaty rights of the Aboriginal people of Canada are hereby recognized and affirmed. Their rights, Aboriginal rights and treaty, are hereby recognized and affirmed. So what this means is to entrench. So entrench just means constitutionalize, as in to insert it in the constitution. You know, which sort of, I mean, constitution, every country is the grand norm, is the highest law of the land, right? So is to say that the Aboriginal people, they are part and parcel of Canada, and their rights, without a doubt, is recognized and is affirmed. So, and what are those rights that is being protected by the Constitution? Then Section 91, sub 24, also says that the Queen, it shall be lawful for the Queen and to sort of to put the jurisdiction to legislate over Aboriginal rights and title in the federal government, right? So the Indians and lands that are reserved for the Indians, the federal government of Canada has exclusive jurisdiction to legislate over that matters or those matters. So things that affect their Indianness, not just every matter. So it's not correct to assume that the provincial law doesn't apply to Aboriginals at all. That's not correct. But things that affect their Indianness, their components as Aboriginals, and lands that are reserved for them, right? Things that are within the exclusive jurisdiction of the federal government. So in this chapter, I will be talking about how do we reconcile crown sovereignty and title and the rights of Aboriginal people. You know, so when the European came to Canada, right, they sort of colonized the people, right? Before then, the title to the land and the sovereignty of the land that is now Canada was resided in the Aboriginal people. So now that the sovereignty has been asserted by the crown, so how do you reconcile Aboriginal rights and title with the sovereignty. So how was sovereignty achieved by the Canadian state? So it was achieved over indigenous land through treaties and of peace and friendship. So when the European came, in order to acquire some of the land of the Aboriginal people, they signed treaty of protection, just like they did across different colonies in the Commonwealth area, the British people. So they signed treaties because they had guns and arms and ammunitions. So they said, look, I mean, surrender your sovereignty, your control over this land in exchange for protection. So we are going to protect you against your enemies, insofar as you surrender your sovereignty to us. So some of them treaties were signed between the colonial government and the Aboriginal people. Some other Aboriginal people did not sign the treaty. You know, some of the treaties were written, some of them were not written, right? And over time, as demonstrated in the case of R and Silly, the Aboriginal rights of fishing was not recognized by the Crown, because they prosecuted Silly for fishing over prohibited areas, and things were. I mean, the Aboriginal people, maybe the place to start is to say the Aboriginal people, they had some certain cultural rights that were unique to them. So their fishing rights, hunting rights, their rights over certain areas, they have some cultural rights. So during the treaty making process, the Crown agreed that, okay, you've surrendered your sovereignty, you will be able to still exercise this fishing rights or this hunting rights or this grazing rights. All of those Aboriginal rights were preserved by treaty. But over time, the Crown began to enact laws that not only affected the new Canadian states, but also Aboriginal people were prosecuted for violating these laws, notwithstanding that there was a treaty that they could continue exercising these Aboriginal rights after the Crown had asserted sovereignty. One of the things that also that the Crown also did was that they compelled the Aboriginal people to relocate. They dispossessed them of their land, and they were pushed to the fringes, to certain tracts of land, and their cultural heritage, as we'll see in some of the articles, how the Department of Government for the Indigenous and Northern Affairs Commission, how they sort of push the Aboriginal people to the fringes of Canada. They established residential schools for them. In these residential schools, they were forced, their kids were forced, they were deculturated, if there is any word like that, right? So their culture were taken away. They were not allowed to speak their languages, and we'll see, I mean, even in modern times, that is also happening, in the sense that most of us, particularly the immigrants, will see that maybe our kids cannot speak our native languages and all those kind of things. So those were the things that were happening to the Aboriginal people. They were pushed to the fringes of Canada, and their kids were made to attend residential schools, and they were forced to assimilate and drop their culture, right, and taught a different culture, right? So a whole lot of, I mean, the residential school system is really a very touching story in Canada. So those are some of the wrongs that the Crown committed against them prior to the constitutionalization of the rights of the Aboriginal people. So here as well, we'll be looking at what is the test for identifying the presence of Aboriginal rights and title, right? So I mentioned that after all this background, this historical experience of the Aboriginal people in 1982, right, the Constitutional Act entrenched the rights of Aboriginal people, that it is recognized and affirmed. So, which was sort of a clawback by the Canadian government to say, oh, you, these Aboriginal people, we've treated you unfairly, we've exercised excessive sovereignty over you, we've forgotten that this land originally belonged to you, and we've sort of tried to, we've discriminated against you a great deal. So we need to begin to recognize this your rights, right? So what Section 35 does is that you cannot just abrogate the rights of the Aboriginal people, and also irrespective of whether those treaties that were made with the Aboriginal people were oral or were written, it is recognized and affirmed, right? All the land claims agreements that was signed with Aboriginal people, they are also recognized, right? So, but what are the tests for identifying the presence of Aboriginal rights? You know what? So that the case of Aaron Van der Peet and Sale Cotton deal with this thing. So, for example, there has to be, it must be shown that that's rights, that the fishing right or the hunting right was exercised by the Aboriginal people at the time that sovereignty was surrendered. So it is not that Aboriginal people will begin to claim new rights that were not exercised by their forefathers. Yeah, so it has the right for it to qualify as Aboriginal rights. It must date back, right? And it must have been consistent over a long period of time, and it must be intrinsic to their Indianness or their character or their culture as the Aboriginal people. And so, what is the status of Aboriginal law within Canada legal order? So, does it have a separate what's it called, status? Or was it extinguished at independence or on the assumption of sovereignty? So, just like we will be familiar in our jurisdiction where it says native law that is not contrary to the doctrine of equity and good conscience and all those kind of stuff, they still survive. So the same thing with the Aboriginal rights law or right and title in Canada. So because it is regarded as native law, to the extent that it is not incompatible with the sovereignty of the Canadian state, those laws are still recognized within the legal order of Canada. So one other principle is that in dealing with when the Crown is dealing with Aboriginal rights and title, the honor of the Crown is at stake. So what does it mean to say the honor of the Crown is at stake? Right? Anybody? Aisha, I'm sure you can help us with that. When it says the honor of the Crown is at stake, what does it mean? Aisha, are you there? Okay, any volunteer? When it says the honor of the Crown is at stake, when dealing with Aboriginal people, what does it mean?
Well, I think what it means is that the Crown is supposed to deal with Aboriginal people in a fiduciary nature, and so their honor is at stake if they do not imbibe that. Like, deal with them in a fiduciary nature means that they have notice, either constructive notice or real notice of the fact that certain aboriginals, maybe they actually own that land and things like that. They should deal with them in the right way by either giving them notice or consulting with them and having a dialogue. That's what I think.
Okay, thank you, Dara. You are absolutely right. So, the honor of the crown basically means that the crown should act as a trustee, should act as a fiduciary for the Aboriginal people. And when you are acting as a fiduciary, it means that you have to act with good faith, right? You don't have to insist on everything you don't have to be rigid, right? You should act as if you are acting for your own affairs. You should act with good faith, and if there is any slight indication that the Aboriginal people have a right or that they might succeed, that the crown should just allow them. They should not be so strict and pedantic with the Aboriginal people. And because they are custodian, I mean, in relation to the Aboriginal land, right? That the crown is holding those Aboriginal land, should use it in such a manner that does not violate the rights of the Aboriginal people. And when it wants to take over their land, right, so it should give them notice, it should give them compensation, it should consult with them, it should accommodate them. So it should just be kind and gentle with them, because the crown is deemed a trustee for the Aboriginal people. So those are some of the things that you will come across in an exam situation. Then we will go to a number of cases here. One is Delgamuku and BC, and basically the case says that Aboriginal title is a burden on the crown's underlying title. So Aboriginal title is a burden on the crown's underlying title. So means that even if the crown has title to land, the Aboriginal title is still burdens that crown's title. Or if the Aboriginal people if they've been given rights to use a land, that land, they are holding it for the benefit of the present and future generation. So when they want to surrender, so Aboriginal land, for example, cannot be sold to private parties, because the rights or the title of Aboriginals inserted in the land is also burdened by the crown sovereignty, which basically means that the Aboriginal people, they cannot do whatever they like with their land. If they want to surrender title to land, they have to surrender it to the crown, right? And the crown will now decide on what to do with that land. So reversionary rights to Aboriginal land goes back to the crown. So they do not have right to sell it, and they cannot extinguish crown title to the land. Then we'll also examine the United Nations Declaration on the Rights of Indigenous People, right? The UNDRIP, which sort of, is United Nations articles. It's a declaration of United Nations which sort of affirm the rights of Indigenous people and how Indigenous people across the world, particularly, across the world generally, right? You have a lot of Indigenous people in North America, so in Canada and the US as well. So recognizing, it's a declaration recognizing the rights of the indigenous people and how the states should relate with indigenous people, right, in order not to extinguish their rights. So there is this article by Naomi Walkan. It's a human rights to self-government over First Nations, child and family services and beyond, and the implications of the Caring Society's case. So in this case, I mean, the Canadian Human Rights Tribunal released a decision. The case is called the Caring Society case, and we sort of address or discuss that which found that the Department of Indigenous and Northern Affairs, the way they have designed their program and control of the child welfare services on the reserve area, and the funding formula caused a number of harms to the First Nation children and families that amounts to discrimination. So we discussed earlier how the Canadian states, how it treated the indigenous people so unfairly. So this case is an affirmation of that. It sort of chronicled the different experiences of the indigenous people, and how their rights were violated, and affirm their right that First Nations are entitled to child and family services that meet their cultural and historical as well as geographical needs and circumstances. So in those reserved schools, they ought to, there was no reason at all to violate their cultural rights, right? So you can teach them, you can educate them in a manner that preserve their cultural and geographical needs, and you don't need to assimilate them. You don't need to discard their culture completely in order for you to be effective, right? So the second article is by Brenda, and it talks about and is about implementing the UN Declaration through domestic legislation, and how I mean, there was a bill, they call it Bill C-262, which was introduced by a member of parliament, and what it sought to achieve was to domesticate the United Nations, the UNDRIP in Canada, so to sort of make it a domestic law. I mean, the status of that bill now is that it was not passed, in summary, but what the bill sought to achieve was sort of give recognition to the rights of indigenous people. When the bill was introduced, there were a number of reactions to it. Some thought it was a welcome development. Other people argued that it was duplicative because the Constitutional Act already recognized the rights of the Aboriginal people, and there were framework within the Canadian legal system that sort of they protect the rights of the indigenous people, and that the UNDRP DRIP was uncertain in its terms, and it was going to create problem within the Canadian constitutional framework. So the argument was also that even courts in Canada, they were mandated by law or even by judicial principle to sort of consider international law in interpreting local laws. So that UNDRP was already, that declaration was already in the consideration of Canadian courts in the interpretation of Canadian law. So there was no point domesticating the law, really. Now, some people argue that way. But this also argues that Canada missed a very important opportunity of showing the world that it recognizes and respects the rights of the Aboriginal people, because the UNDRP provide a framework where there will be periodic reports to say, in this year, this is what we have done in terms of advancing the rights of the Aboriginal people and all that. So the bill was not domesticated, and the author believed that Canada missed a very important right. Very quickly, we'll run through the cases. Rio Tinto deals with the duty to consult, right? So when the Crown, before it does any action that infringes on the right or title of Aboriginal people, it should consult them. And the duty to consult arises when actual or constructive, that's what Dara was referring to, when actual or constructive knowledge of Aboriginal rights or interests or cause. So they must not have actual knowledge, right? The duty of honor of the Crown means that even if there is a constructive knowledge that in this our action, Aboriginal rights and title may be affected, the Crown, which is the executive arm of government, has a duty to consult with the Aboriginal people, right? As we'll see, the legislative or the parliament does not necessarily have the same obligation, but the executive arm, whenever they want to perform any executive action that will affect the rights of the Aboriginal people, they have a duty to consult them and accommodate them as well. In Chippewas and Enbridge, it says who has that duty within the executive arm. Is it must it be the Prime Minister himself, or must it be the federal cabinet itself, or administrative body can consult the Aboriginal people on behalf of the government? So this case basically says yes, the what's it called, the admin body can consult the Aboriginal people on behalf of the federal government. So the in Mikisu Crew and Canada, it's sort of gives credence to what I said earlier, that duty to consult Aboriginal people doesn't arise in legislative action. So the parliament does not have to consult Aboriginal people in enacting their law. Passion and Dean First Nation says that when the court is reviewing Aboriginal matters, it should be based on reasonableness. So we'll talk about standard of review and all those kind of stuff in chapter 10. Then this very interesting case that was recently added is Queen versus Richard Lee de Saltel. The case is a decision of the Court of Appeal, so we're still waiting for. I think the right has been given for the matter to proceed to be heard by Supreme Court. So it will be interesting how that case turns out. So what I find interesting in this case is that I mean, an American came to Canada, British Columbia specifically, and I think he was hunting or fishing or any of those things. And when he was prosecuted, he claimed that he was exercising Aboriginal rights, right? So it was interesting because, I mean, you are not a Canadian. How do you say that you are exercising Aboriginal rights and title, right? So the Crown, of course, argued that that's recognition of Aboriginal rights and title is given to citizens of Canada or Canadians and does not extend to non-Canadians, right? So interestingly, the Court of Appeal took a different view, disagreed with the Crown, and say that Aboriginal rights and title that is recognized in the Constitution is agnostic to persons, to nationality. So you don't have to be Canadian. Once you can establish that your ancestors were part of those Aboriginal people, and that right was recognized by the Canadian Constitution. So you can claim that right without being Canadian, which is what happened in that case. And we'll see that because, I mean, the US and Canada, they share borders. So it is quite understandable that you have people of the same tribe or indigenous or the indigenous people falling across different borders, right? So I mean, the decision makes a lot of sense to me, but it will be interesting how the courts will look at it. So basically saying that that's right, that the Aboriginal right that is recognized by the Constitution, it is not specific to Canadians. In as much as you can prove your aboriginality, if I can put it that way, that right will be protected. So we also look at the case of sea cutting nation. What do you need to prove Aboriginal title? I think I've mentioned some of them. Then Daniels and Canada try to explain who are the Aboriginal people. Does it include those that have been registered, the status and non-status Indians, and what have you? So I don't know how much time we have, so I'll just do we have comments, contribution? I think we have just about 7 minutes, so I don't know if I should go to chapter 3. Lola, you want to say something? Go ahead, please.
Thank you so much for demystifying this. Like after this, what is it doesn't look like it will be as difficult as it seems. But I probably would say it needs more time and concentration. But it seems more like history, and it seems more like what I would enjoy.
You will enjoy it, I can assure you. It's quite interesting. I mean,
yeah, I'm sure after by tomorrow I'll make up my mind and start the registration for my exams.
Okay.
Thank you very much. It's really appreciated. Thank you.
No problem. Aisha, you want to say?
Hello.
Yeah, Aisha.
Can you hear me?
Yes, clearly.
Oh, so sorry, my screen is frozen, so I was even trying to unmute. I didn't know that worked. So I mean, I have no questions so far. I'm enjoying it, so fingers crossed. Still right. Open. So I wish we could go forward and do more, anyways. So.
Okay. So any other comments? Okay, I'm not. I mean, chapter 3 is about sources of Canadian law. So the general sources of law, the received English law, the Civil Code of Quebec, the common law, equitable doctrines, international law, treaty, and how Canada is a mixed law jurisdiction, so to say. So when it says is a mixed law jurisdiction, what does it mean, right? It just means that both the common law and the civil code operate in Canada. So that's the whole concept of bijuralism. Just common law and civil code operates in Canada. So in Quebec, we have the civil code operating at the provincial level, right? While the common law operates at the federal level, right? And in every other province. So in all the other 9 provinces, the common law operates both at the federal and provincial level, while in Quebec, the common law operates only at the federal level, and the provincial, the civil law code or civil law operates at the provincial level. So we would, I mean, we'll be looking at that. So it's just to see how the influence of common law in the general law of Canada, the influence of equity in the laws of Canada, and the treaty making process, and how international law also influences the interpretation of law in Canada. So that's the summary of chapter 3. No issues, quite straight to the point. Number of articles there, and we'll look at that. Chapter 4. So I'm trying to see how much I can rush before my administrator kicks me out. So chapter 4 talks about the fundamental principles of Canadian legal system. So the basically 6 principles: rule of law, constitutional supremacy, parliamentary supremacy, federalism, separation of power, judicial independence, and all those are the underlying principles of the Canadian legal system. So we'll look at that in details. So I've been warned by my administrator to round up. So again, thank you very much for joining the class. Thank you for your contribution. Our intensive class starts December 9, right? And we would it runs through to January 9, and we'll go into details on some of these subjects. And also the exam, the exam is in February, so I think there is sufficient time to sort of prepare for the exams and run through the course. Like I've been saying, I think the course is quite simple and enjoyable. Once you just need to spend more time in looking at it, and it's like an opening to other courses as well. So you can register for our intensive class if you go to www.ncaguides.com. You can send an email to inquiries, QUIRIES at ncaguides.com, and you can send me an email at Masood, MASUD, at ncaguides.com. So again, thank you very much, and hope to see you from December 5. Thank you very much.
Thank you so much, Masood.
It was such an enlightening class. Yeah.
What did you say?
I said it was such an enlightening class. So thank you.
You're welcome.